Okay, my name is Stacy Reynolds. I'm an attorney at Atlanta Legal Aid, and I again appreciate the Atlanta BeltLine partnership for allowing us to do these presentations. You may have seen some of the ones earlier that we did, particularly about how to file your property tax appeal. And we've been meaning for years to do one on what to do when you get the notice that you have this Board of Equalization hearing. So we're finally doing one now. So you're probably tuning in because you got this. Basically, it's a notice telling you exactly when and where your Board of Equalization hearing is. And it can be either virtual or it could be in person. So you want to be sure to pay close attention to what it says and when it's going to be. You are allowed to reschedule it one time, but you have no control over when it's going to be rescheduled. So keep that in mind. And the next time it gets scheduled, you're going to have to show up, or else they're going to go ahead without you. So anyway, so once you get this Board of Equalization hearing notice, we often get these questions, what do we do now? So the idea of this is to go through and figure out what you do now. So we're going to go through this kind of in 4 parts. What did you submit already? Think about, what were you thinking when you appealed? Reviewing your evidence, and that's going through the research that you've done, looking at other evidence, considering what argument you're going to use to support a lower value. Prepare for the hearing. This is, gathering up your evidence, organizing it, getting your argument in place, getting everything ready for that hearing. And then the hearing day is, we'll talk about like what happens that day in the hearing, and then also a little bit about what's going to come after that. Let's start with reviewing your appeal. You want to go back and look at what you have. Hopefully you have a copy of what you filed. If not, you can kind of go back and kind of think through what you were thinking. There were basically 3 grounds for appeal. There's uniformity, also known as equity. And this is when you're saying basically that the values the assessor has for other houses is lower, and therefore it's not fair to value your house higher than that. So they should lower your value to be more uniform. The second grounds for appeal, there are 2 different pieces of it, but it's called a value appeal. And that is when you're arguing that the condition of your house would merit a lower value. Either they don't have the correct information about your house, or they just don't have the full information about like what's on the inside of your house, that if they knew everything, that they would lower the value. Or that the sales in the neighborhood would suggest that you get a lower value. When you're looking at the sales in the neighborhood, you want to look at last year's sales. Basically, they're trying to figure out what the value is as of January 1st. So they're going to look at the prior year's sales. Any sales that have happened recently are going to go into valuing it for next year. So you want to be sure to be looking at last year's sales. For the uniformity, it's this year's value, what the assessors have for this year for the other homes. The third ground for appeal is exemption denied, and that's when you've applied for a homestead exemption and you're not getting it. We're not going to talk about that today. Today, we're just going to be focusing on the uniformity and value appeals, and how to sort of prepare for those. If you have questions about exemption denied, feel free to reach out to me. My contact information will be at the end of this presentation. So again, the goal for what we're doing is to try and present evidence to the Board of Equalization that convinces the home that it's more what you think the value should be than what the assessors think it is. So you want to try and show that your house should be valued at a more modest home rate rather than at the grand mansion that the appraisers seem to think it is. Part of this is we're going to be looking at comps, or comparable properties, and a key piece of that is what is similar. If you're in a neighborhood where all the homes are the same, it's very easy. They're going to be similar. But in most neighborhoods in Atlanta, you're not sitting next to the identical house. You're actually going to be sitting next to a house that's quite different often, and sometimes that's the only thing you have to compare your house to. So, they're not equal, but what you might be able to do is use the price per square foot to make them similar, to try and show that, the price that was paid for this larger house is, would result in a lower value for my house if you looked at the price per square foot that was paid. So those are all things that we were thinking about when we were filing the appeal. Let's review what evidence you have. If you have not already done your research, now is the time to dig in. You have got to get the research done now so that you can have it ready to present at the Board of Equalization hearing. You need to get your ducks in a row. And this can get a little complicated. You can see the ducks are not really in a row. So this is the time to start working on that. Review your evidence. If you did one of our workshops, what you have is probably some comps, some comparable properties to argue for a lower value. Look at those. Think about any other evidence that might be able to support a lower value, things like an appraisal. If you have an appraisal that shows a lower value that was done recently, then you can use that to show that, really my value should not be this high. Also, repair estimates. So if there's something that needs to be fixed and you have an estimate for how much it's going to cost, you can argue that we just need to take that off the top of what they have for the value. Pictures, especially if you're doing any sort of condition issues, you want to be sure to have pictures of those. Those will really carry a lot of weight with the board to be able to see what that issue is that you're talking about. Internet searches can also be helpful if you're, like looking at sales. You might be able to find the listings for the houses to compare it to. All of these things can go into help you paint the picture of why your value should be lower. The testimony that you present is valid evidence. That is evidence in itself. But think about also adding in pictures and charts and things like that, because those can help support what you're saying and can really reinforce your side of the argument. Especially when you're thinking about charts, this is basically what the appraiser is going to be using. They're going to have a chart that shows, the first column is going to be your property, and then they're going to have 4 or 5 other properties that they're comparing your home to. They're using that to show that really the value that they say it is in line with these other properties. And they're cherry picking properties, so you can do the same. You can create a very similar chart using the properties that you have that present a lower value. Now, this is the one for uniformity. So when you're looking at this, what you're going to want to pay attention to is down here at the bottom where I've got the red box. That's going to be the fair market value that the assessor has for those properties. And then they're going to do a price per square foot. Basically, they're dividing the fair market value by the square footage of the home to get a price per square foot. So you can see how those things compare one to one. This is the one that they would use for sales. And with this one, you're going to look at, for all of the comparables, that they're all going to be ones that were sold in the prior year. And you're going to look at the information that they have about that sale price and compare that to the fair market value and the price per square foot for your home. Okay, buddy. So because they're using this kind of chart, you can create the exact same thing or something very similar, and it's something that's very comfortable for the Board of Equalization to look at. So it makes it easy to be able to show them that, hey, the appraiser has their cherry picked properties, we have ours. These are the ones that we think are more accurate for the value of our home. And that can carry a lot of weight. And again, something that they're comfortable with looking at. When you're thinking about your evidence, there's some things to keep in mind. You want to be aware of any pros and values. So if you're using comparable homes for the uniformity argument, if that property was appealed last year or the year before, then the value that you're looking at is not really the value for this year. It is actually the value for whatever year it was appealed. And so they're going to say that that's not going to be a valid comparable. You want to avoid uninhabitable properties unless the property that you're appealing is also uninhabitable, because just by being able to live in the home, there's going to be some extra value that they're going to consider to be added to it. You want to try to use valid or qualified sales when you're looking at the sales in the neighborhood. But if you can't find it, if you have some sales that you think are more like what your property would be, just be ready to justify that. For example, if it's some sales to investors, where the home was sold as is to an investor, that may be the way your house would go. If you were to sell it today, it would be, as is. And so you can argue that we think that that should still be a valid comparable. Keep in mind that affordability is not actually grounds for lowering the value. It is sympathetic, but it's not going to be enough to say, well, I just can't afford the taxes. You're going to have to be able to present something to show that the value should be lower. You can ask for their evidence. You can email the Board of Assessors at this email address to ask them to send you what they have. You need to do this at least 7 days before the hearing. As a practical matter, you can probably get away with doing it later, but the law basically says that you're supposed to do this at least 7 days before the hearing. Now, keep in mind that if you ask for their information, they can also ask for yours so that they can have that ahead of time as well. But getting their information allows you to look at their comps and consider what reasons their comps are not as good as yours. So you can look and say, well, this house, yeah, it was sold last year, but if you look at this multiple listing service listing, it shows that this house was in much better condition than my house. It was all fixed up. It had all the amenities. So, it gives you a chance to be able to find holes in their evidence that you might not have the time to do if you're just looking at them at the hearing. Part 3, preparing for the hearing. That train is about to arrive and you need to be ready. You need to be packed and ready to go to be on that train when that hearing starts. You need to organize your argument. Be concise. You are going to have less than 10 minutes. Usually it's going to be like 5 to 7 minutes to be able to present your side of the argument. You're going to need to be able to very quickly show them, this is why I think my house should be valued lower. You have to assert a value. So in looking at your evidence, figure out what value can you actually defend. When we were filing the appeals, we said just lowball it, kind of go on the low end. Now you need to be able to put your money where your mouth is. You need it, even if it's not the same value that you had at the time you filed your appeal, whatever value you tell the board when you show up, you need to be able to show some evidence to support that it should be that low. You need to be able to argue why your value is better than their value and how your evidence supports a lower value. All of these things need to be sort of in your mind as you're organizing that argument and getting it ready for when you go in for your hearing. You also want to consider the evidence that the county may present and be ready with, counter arguments to whatever they have. Think about the weaknesses as well as the strengths of both your argument and theirs so that you're ready for whatever may happen. Prepare your evidence. You want to be sure to have your exhibits organized. You need to have them in a format that works for how you will present them. If you're doing a virtual hearing, you want to be sure that you have your exhibits in a way that you can share your screen and show them. Or if you're going in person, you want to have them in clear copies so that you can hand them to the board. You can email, fax, or mail your evidence to the Board of Equalization ahead of time. It does have to arrive more than 48 hours before the hearing. With a fax or email, you might be able to do that pretty quickly, pretty close to the 48 hours. For mail, you're really going to have to allow so much time that you want to be careful if you're going to mail it to the Board of Equalization. If you do that, they should be able to get the copies to the Board of Equalization members ahead of the hearing. This could be something that, if you're doing a virtual hearing and there may be some technology issues, this is one way to sort of assure that they're going to have that, even if you do run into those technology issues. But, if you're actually attending the virtual hearing and there are no technical issues, you can just present it, by sharing your screen. In person, you're going to want to bring copies, and when you bring copies, you're going to need to bring 5 copies of it because there are 3 Board of Equalization members plus the appraiser, and then you want to have a copy to be able to refer to as you're talking. You also want to consider the logistics for attending the hearing. And this is, plan ahead. You want to know exactly how to get to the hearing and how much time it's going to take. If you're going to do a virtual hearing, practice with Zoom. Use the Zoom actually has some things where you can actually go in and do a practice meeting, or, you know, get friends or family who have Zoom to be able to help you, you know, practice how to share a screen and how to log in and all of that stuff. If you're doing it in person, be sure you're planning the route to get to the hearing, where to park, how much time it's going to take, and then add some. And that's, you know, for logging in and for attending in person, allow extra time, because you never know what kind of problems are going to come up. If you have a problem, call the Board of Equalization as soon as you can to alert them that there is a problem and that there may be some problem with you arriving on time. Technically, they take the position that if you're not there, they can just go ahead and have the hearing. So that's why you want to allow the extra time. You want to be sure that they don't have the hearing without you. If you're going to have someone who's going to represent you in the hearing, they're going to need a letter of authorization. And this is going to be just a very simple form that just says, you know, I, homeowner, authorize, you know, X person to be my authorized representative. It needs to be sure to have the address and the parcel ID number and signed by you. They're going to need to have that. Ideally, they want to submit that ahead of time to the Board of Equalization, but they can also just bring it with them to the hearing. So now you're ready, hopefully. So you're going to show up for the hearing. I will say this picture, I chose this picture because even though it's a little bit more casual than the actual Board of Equalization hearing, it's not that far off. Basically, you're going to have 3 Board of Equalization members sitting on one side. There's going to be you arguing your value and the appraiser arguing the value for the county. And you're all just in this room, you know, having this discussion, basically. It's not that formal. Now with the COVID, when you're actually in person, you're now a little bit more separated. You have the plastic plexiglass dividers between everything. So it's a little bit more intimidating than it used to be. It used to be literally sitting around the same table. Now you're a little bit more spread out, but it's still the same thing. It's still just 3 people there listening to the arguments and 2 people making the arguments. So it's not that formal. At the hearing, you do have the option of whether to go first or second. There is no right or wrong way to do it. It's whatever you prefer. You can let the appraiser talk so that you hear what they have to say and then respond to it, or you can go first. If you're worried about not having enough time for your argument, you may want to go first just to make sure you don't run into that time running out. They're going to be pretty strict about the 20 minutes of the hearing. But, you know, whichever way works best for you. The appraiser does have the burden of proof, but they can generally meet it. Basically, they show up with that chart showing, you know, your property and some others. That's enough. They've presented evidence that gives facts that support their value. So you need to do the same. You need to be prepared to provide your own evidence or show the weaknesses in theirs, or ideally both of those things. You want to show the evidence to show why your value should be lower and why their value isn't really accurate. You have to give the Board of Equalization a reason to lower the value. Again, just saying that you can't afford the taxes is going to be sympathetic, but it's not going to be anything that the Board of Equalization can do anything about. They have to have some reason why they think the value is lower than what the county thinks it is. The hearing is not very formal, but the Board of Equalization is going to want it to be orderly. So while you're in there, you want to be careful not to be talking over the other person, if you can avoid it. You also want to try and keep from sounding angry or snippy. That's a pretty easy way to alienate the Board of Equalization. Often, well, some boards of equalization will allow you to have kind of a conversation with the appraiser as, you know, as either side is presenting. They'll allow both sides to sort of talk. Sometimes they're going to be very strict about, like, no, you can't talk. And especially if you're talking over someone, that's when they're really going to shut it down usually. And they'll say, okay, this is your time to talk. This is the appraiser's time to talk. When the appraiser's done, then you can respond to it. They're not going to allow that back and forth. Some of them will. And so you kind of want to gauge the room to see what works. the goal. You want to come across as sympathetic and reasonable. In addition to just having the evidence that allows them to come to a lower value, you want to make it seem like this is something they should do. This is, they can feel the sympathy for you and that it's reasonable to lower the value. And then if you've given them anything that they can hang their hats on, then hopefully they'll lower the value. That's the goal. At the end of the hearing, they'll actually render the decision while you're sitting there. They'll actually sit there and talk amongst themselves to decide what value they think it should be. They'll tell you what that value is. And if you're in person, they'll actually give you a copy of that value, of that decision before you leave for the day. If you're doing this virtually, they'll mail you a copy of it. But you'll know the answer right away of what that value is going to be. This is what the decision is going to look like. It's going to give the 100% value, the 40% assessed value, so that's the taxable value. And then the comments, they're always going to say based on evidence presented. They're not going to identify what evidence was persuasive to them. They're just going to say based on evidence presented. And then all three members of the Board of Equalization will sign it. After the decision, hopefully you'll look like this. You'll be so excited that the outcome went your way. But you keep in mind that there is 30 days to appeal. If you're not happy with it, then you have 30 days to appeal to Superior Court. The 30 days to appeal is also important even if you are happy about it, because basically they're going to wait out that period before the tax commissioner does a final bill. So keep in mind that there is going to be a final bill at the end of all of this. Once that time for appeal has passed, then the value that has been decided by the Board of Equalization will be sent over to the tax commissioner. The tax commissioner will recalculate your tax bill based on that number. And if the value that you end up with is more than the value that your temporary tax bill was, then you'll owe some more taxes. Keep in mind that the temporary tax bill is usually based on last year's value or 85% of this year's value. And so often the end result ends up being at least a little bit higher than that. So usually you'll end up owing at least a little bit more in taxes. And so you need to pay that final bill. If it turns out that the value you get is less than what your temporary tax bill was, then they'll send you a refund for that difference. If you are unhappy, you can appeal to Superior Court. You're going to need to do that by submitting the appeal request in writing to the Board of Assessors. I'll say this is the way the process is right now. This process is going to change next year, but at least for the 2022 appeals, you'll still submit the appeal request in writing to the Board of Assessors. The first thing they're going to do is they're going to schedule a settlement conference before it gets referred to Superior Court. And that's going to be, one last opportunity to try and come to an agreement with the Board of Assessors about what the value should be. And if you can reach an agreement, then you're done. If you can't, then it's going to get referred to Superior Court. You're going to need to pay a $25 filing fee. And then it's going to be the judge who decides what the scheduling is for everything after that. It's going to become much more formal. And instead of the appraiser being the one making the argument, they're going to be represented by the county attorney and anything that goes after that. So to recap, your property tax appeal is your chance to argue to reduce the value. You're trying to get them to reduce the overall fair market value that they have for your property, because that's going to reduce the taxable value, which reduces your taxes. So that's why you're trying to get a lower value for this. You need to present evidence for why the value should be lower. The Board of Equalization is not scary. It's basically just 3 individuals who are also taxpayers like you, who have been chosen to serve on these boards. They've gotten a little bit of training, but they're still going to have much of the same concerns that you do. So it's not intimidating. It's not like you're going in front of a big mean judge or anything. No matter what the outcome is, if you show up for that Board of Equalization, you're going to get a 3-year freeze. So whatever value you get in this appeal is going to be the value for this year and for the 2 years following it. So what that means is even if you lose, you still won't the value still won't go up the next 2 years. So that can be a win in itself. And you can do this. You can. This is not that hard to do. It's really just about trying to be reasonable and explain to the Board of Equalization why the value should be lower. That's my presentation. Do y'all have any questions or other comments that you want to add?
Thanks, Stacey. Always appreciate your expertise with this. The only thing I would add is if you have any questions or want more details on how to do the research for both the uniformity or the value argument, make sure you refer back to our workshops from earlier in the year. That's on the Atlanta BeltLine YouTube channel or at beltline.org/empower, and Stacey and Carrie will go in depth into how to do the research.
My guess is that this presentation will probably be shared on the Atlanta BeltLine Partnerships website, and so it'll probably be very close to where those videos are, so it'll be easy to find them. And Carrie, I know you've done a bunch of like hearings and preparing for hearings, so do you have any suggestions that I didn't cover?
I think that you did a great job at covering them. I will say that I work with some volunteer attorneys on these, and sometimes people think of these hearings as, like Stacey said, they are more casual than you might think of a legal hearing to be. And in general, if you think that you have some evidence that supports your argument, you might as well bring it with you and present it. And then let the board decide whether they will consider that evidence or not, or how much they'll consider that evidence. But if you think you have some evidence, I think it's worth bringing.
Yeah, and you can get creative on what basically what you want to do is think about what value you think your house should be and what evidence supports that. So you can be creative on what kind of evidence you bring. I think that's it. Like I said, you can do this. This is not that hard, and the boards of equalization generally are fairly reasonable.